use of the cooler mornings. So welcome everybody. Thank you for joining us today as we receive our briefing from National on the Upstream Petroleum Bill. With that, I wanted to warmly welcome the officials from the Department of Mineral Resources and Energy, and officials as well from Environmental Affairs and Developmental Planning, as well as any members of the public who might have joined us today or who might be watching via the YouTube live stream. I would just like to note before we hand over to introductions that we have received apologies today from Member Seleko, who has kindly asked Member Falanda to stand in for him. We have also received an apology from our permanent delegate, Kathy Labuskaghni, Member Kathy Labuskaghni, and from the Department of Economic Development and Tourism. So noting those apologies, I will hand over to members to introduce themselves.
Good morning, Chairperson and members. Wendy Kaiser Falanda, alternate member for Member Seleko this morning.
Good morning, Chair. Andrikus van der Westhuizen, member of the Standing Committee on Finance, Economic Development and Tourism.
Good morning, Chair. Khalil Brankais, a member of the Finance Committee. Thank you.
Good morning and welcome, members. I think that's all the members that we have today. I'll now hand over to officials from DMRE to introduce themselves.
Good morning, honorable members. Good morning, Chairperson. My name is Dr. Olga Masekwa. I am the Chief Director responsible for mining and petroleum policy within the DMRE. Here with me, I've got Ms. Mamohali Stella, who is the Director, Mining and Minerals Policy Development. We do have Mukondi Ndou, who is the Deputy Director in the same section, and Tebo Makhasha, who is the Assistant Director in the Policy Unit also. So thank you for the opportunity to make the presentation.
You're very welcome. Are there any other officials, perhaps from Environmental Affairs in the Western Cape, who might also want to introduce themselves?
Good morning, Paul Hardcastle, Environmental Affairs and Development Planning, Directorate Planning and Policy Coordination, and with me in the meeting would be Anique Rousseau and Marianka Low from the same directorate. Thank you.
Thank you very much, and a warm welcome, pardon the pun with the weather, to today's committee. All right, so with that, I'm just going to briefly touch on our rules for engagement today. So essentially, we know that this is a virtual engagement. So if you could please kindly keep your selves muted and keep your cameras off unless called upon to speak. This will just ensure that we have a smooth sailing a meeting as possible. And also, if you have any points of orders, members, please use the chat function on Microsoft Teams. There will be opportunities to ask questions, so please, of course, wait until that period, and your hand will be recognized accordingly. So, noting the apology that we have received, we will not have a consideration from the permanent delegate at the NTOP on opening remarks. So with that, I will hand straight over to DMRE to make their presentation. And then from there, we'll move on to our question and answer session. Over to you, DMRE.
Thank you, Chair. Are we sharing from our side?
Yes, please.
Thank you.
Just confirming from my side, I can see everything perfectly.
Thank you. Good morning, honorable members again. Our presentation today, we are going to be presenting about the UPRD bill. We call it UPRD bill, Upstream Petroleum Resources Development Bill. In terms of the background and the overview of the related legislation, we'll also touch on the process followed, the objects of the bill, and we will also outline the provisions of the bill. I understand that members have received a copy of the bill, so we will touch on strategic clauses that we think it's important or necessary for members to understand, and we will then conclude with a way forward. Apologies from our side. We are trying to move the presentation. So in terms of the background, the development of petroleum resources is currently regulated under Chapter 6 of the MPRDA, which is the Mineral Petroleum Resources Development Act. And these provisions in Chapter 6 of the MPRDA do not sufficiently address pertinent issues required for the development and growth of the upstream petroleum industry. Therefore, the department decided to sort of separate that chapter to develop a UPRD bill. The draft bill is meant to strengthen upstream petroleum provisions and presents a value proposition for South Africa. And in terms of when we talk upstream petroleum development, we mean exploration and production of oil and gas. So in terms of historical background or the overview of the legislation, pre-1911, the mineral sector was regulated by the Mines and Works Act, which focused on mining, and there were no provisions for oil and gas in that legislation. And then in 1991, the department then promulgated the Minerals Act, and oil and gas resources were defined as minerals with no dedicated provisions for oil and gas in that bill, in that act. And then in 2002, the Department of Mineral Resources and Energy promulgated the Minerals and Petroleum Resource Development Act and moved oil and gas provisions from the Minerals Act as an appendage to mining. And then in 2021, so discussions around having a focused legislation for upstream petroleum resources has been underway for some time. And then in 2021, the department then started the process of developing the bill. The process followed include that the department conducted research and benchmarking. And one of the issues that they had to do was to also look at similar jurisdictions in Africa and overseas. And some of the countries, just to mention a few, include Angola and Congo, and Norway, Nigeria, Brazzaville, Congo, Brazzaville, Canada, and USA. These were jurisdictions that the department believed could be benchmarked with, and this assisted the department to draft the bill in consultation with relevant stakeholders. And in 2019, around November, Cabinet approved that the bill be published for public comments. As you will know that our legislative process development is outlined in the DPME guideline. And then after gazetting, a further broader stakeholder consultation was embarked on, which resulted in the bill being redrafted. We had to also consult the state law advisor, who then certified the bill that it was constitutionally and legally sound. We also had to do a socio-economic impact assessment study, wherein the DPME also issued a sign-off certificate and allowed for the process to be tabled in cabinet and then now in parliament, where PPC and parliament adopted the bill in October in 2023. In terms of the objects of the bill, amongst others, are to recognize the internationally accepted right of the state or to exercise sovereignty over all petroleum resources within the republic. This asserts authority over the state, assess authority to the state to ensure that they become the custodian of the resources on behalf of the citizens, and also that the bill seeks to also expand opportunities for Black persons to enter and actively participate in the sector. And one of the issues is that all these are meant to make sure that the petroleum resource development is orderly and there is no damage that is done in terms of its development. In terms of the clauses, I will touch on, so we will not be saying clause 1 to clause 2, clause 3. We will just be touching on the clauses, as I said, that are necessary for members to understand. Some are just straightforward. That is why we omitted them in this presentation. Clause 3 of the bill makes provision for the custodianship, as we have just outlined now. And then clause 8 provides that all acreage for exploration, development, and production of petroleum resources must be administered by PASA. So the acreage is the size of all land, either on sea or in the sea or on land, inland. This development and exploration is controlled by the Petroleum Agency of South Africa on behalf of the department. We then, in this bill, then makes provision under clause 10 for the functions of the Petroleum Agency in order that they can undertake the administration of the petroleum resources in the country. Clause 13 provide for the minister that the minister may periodically, on recommendation by PASA, initiate a competitive administration on open licensing rounds by publishing an invitation notice in the Gazette. So this bill provides for the licensing administration, the process which is done by PASA. So minister may periodically initiate a competitive open license rounds for competitive initiate a competitive administration on open license round and making sure that applications are invited, and that Gazette will have outlined the terms and conditions. Clause 14 makes provision for the duration of the reconnaissance permit and a petroleum right. A reconnaissance permit is valid for a period not exceeding 2 years. A reconnaissance permit is a permit that allows the holder, the applicant, to conduct geological studies and seismic surveys. And once the 2 years is done, then they can move to apply for the right. And then clause 14 provides for that the petroleum right granted in relation to onshore and offshore acreage in shallow waters. It talks about the validity of that right in respect of the exploration phase, remembering that before production, the applicant would have started the exploration phase. So the exploration phase is granted for a period of 9 years and is made up of the initial term of 3 years, a second, third, and fourth term of 2 years each, and in respecting of the production phase for an ultimated period made up of the initial term of 30 years and further terms of 10 years. So when somebody wants to do exploration in shallow waters, this is the phases in terms of exploration and production, or the term that the minister would have granted that right. Clause 14 makes provide for a petroleum right granted in relation to acreage designated as frontier as contemplated in subsection 8.2 and offshore acreage in deep water. So the difference is just either it's in deep or in shallow water, and that term is also divided in terms of exploration phase and also in terms of the production phase, which is similar in terms of the shallow water. Clause 15 makes provision for a competitive administrative licensing round for petroleum right, meaning that the minister may at some point, upon advice by PASA, invite applicants for a petroleum right in respect of block or blocks as specified in the notice. And the notice will prescribe with such applications may be lodged with the Petroleum Agency. So at any point, the minister may have done some analysis and invite applicants to those blocks. And clause 16 provide that the minister may, in the notice of gazette, invite applications for reconnaissance permit in relation to multiple blocks or an area encumbered by exploration. So in terms of the blocks, this is to ensure that there is orderly development. And you remember we spoke about custodianship in the previous sections. So this is to allow the minister to do that. And then in terms of the reconnaissance permit, when minister has invited application, this is to ensure that the state still assess prospectivity of the country, but in consultation with PASA. In clause 19 makes provision for consultation with interested and affected parties. The Petroleum Agency, within 14 days from the date of acceptance of an application lodged, will call upon interested and affected persons to submit their comments and objections regarding the application within 30 days. Then clause 19 makes provision for consultation with affected parties by the applicant. So we have in this bill tried to circumvent or try to have correct some lessons we've learned within the MPRDA, because consultation has been an issue from our side. So there is two parts in consultation. First, consultation by the PASA, and the second is the consultation by the applicant, who will then make sure that there is thorough consultation with interested and affected parties. And then 21 provide for the establishment of the Petroleum Development and Environmental Committee to advise the minister on any objections received pursuant to consultation. So if in the event, as outlined in 19 and 20 during consultations, communities or anyone or any interested or affected parties raise objections, the minister will then establish a committee. This is the same as the REMDEC that we do in mining. And that committee is outlined in the bill, its formation, the experts or the composition of people who will act in that, and even everything, the remuneration. So that committee will then deal with objections as would have emanated from the consultation. Clause 30 provides for the partitioning of rights and further state that the petroleum right may not be partitioned without written consent of the minister. In this one, we are allowing, in the case where any applicant or right holder wants to sort of divide or into parts or sell some stake into other parties. That section provides for that. It cannot be done without the consent of the minister. Clause 31 provides for participation of Black persons in petroleum rights. The bill provides for a minimum of 10% interest in petroleum rights for Black persons on commercial terms that has been retained. So in terms of this one, we are saying the right holders must make sure that their shareholding composes of a minimum of 10% of Black persons in order to be granted the right. And the act or the bill also provides for a definition of Black persons, and for the purposes of the 10% participation by Black persons on commercial terms, it has to be clarified to mean a company that is 50 plus 1% owned by Black persons. Black persons are also allowed to dilute, meaning that they are allowed to sell their ownership shareholding, and they can share for not less than 5% for purposes of raising capital. We understand that there may be issues because this is a very capital intensive sector. So if they want to sort of sell their shareholding, they can only be allowed to sell 5%. A holder of an applicant of a petroleum right who is not able to secure the required Black persons is also allowed an extension of 2 years, meaning that if there are ground or reasons that the applicant would have, or the petroleum right have advanced to say they are not able to acquire that 10% Black participation, they can given a time to do that, which is 2 years. 32 makes provision for the minister to reserve block or blocks for Black persons and invite applications for petroleum rights from Black persons. The provision further provides that Black persons participants' interest in a petroleum right granted to Black persons in respect of block or blocks may be diluted to no less than 30%. So in this one, once they enter without any partner, they can only dilute their shareholding to not less than 30%. This is to ensure, I mean, the government has a prerogative to ensure that they really advance transformation with the legislation that they bring forward to Parliament. Clause 33 makes a provision for the exit of Black persons from petroleum right. Where Black persons exit from a specific petroleum right, the empowerment credentials of that specific petroleum right must be recognized for the duration of the right. So in this one, we are learning also from the mining, where ownership of 26%, there has always been an issue of once empowered, always empowered. So this clause allows that if they exit, the empowerment credentials remain recognized for the duration of the right. Clause 34 provides for state participation in the petroleum right. So the state owned company, members would have seen that the department has gazetted a South African National Petroleum Company Bill in November, which will be closing in the for publication. It was published for public comments, closing around December. So this company is the one that is gonna allow the state to participate in petroleum rights, and the state will has a right to a 20% carried interest in petroleum rights, including in both exploration and production phase. So because we realized that the state will not have enough capital to join on their own, so the petroleum right holder will carry the state by about 20%. And then when there is production or when there is profits, then the holder is entitled to recover 50 to 100% of the state proportionate share of exploration and production costs, respectively. And obviously, this will be in agreement with, in terms of their commercial agreement by the state and the petroleum right holder. Clause 36 provides that a petroleum right holder may sell a percentage of petroleum at prevailing market price to the National Petroleum Company, subject to the terms and conditions to be agreed upon. This one allows that the state can, the petroleum right holder can sell a percentage holding to the company, which we have now established within that bill that I was speaking about. And there's also, this is not going to just be done, because in case there is disputes, there is there's arbitration processes that has been provided for, and an agreement of the sale of petroleum is to be annexed to the petroleum right if that right holder has now sold the percentage share to the state using NPC. 87 provides for the minister, by notice in the Gazette, to invite open applications for petroleum rights in respect of blocks or blocks indicated in such a notice. So minister may, in consultation with PASA or be advised by PASA, invite applications for certain blocks. And this is to ensure that energy security of supply in terms of energy resources in the country. And clause 44 provides for the exception under which the minister may grant petroleum right. And 46 provides for an application for a petroleum right holder to progress to the second, third, and fourth phase. Members will remember that we spoke about that in terms of exploration, either offshore and onshore, there are phases. From exploration is 9 years, and then we spoke about the 30 years. So in each phase at that level, there is going to be some conditions that the applicant, the right holder, must meet, and that PASA will look at it in terms of those sections. Clause 47 provides for exception under which approval may be granted to progress to the next term of exploration, and 52 provides for the right holder may not undertake drilling without a drilling permit. Obviously, this is to prohibit illegal activities, or which we have seen also in mining. Clause 53 provides for the holder of petroleum right, that is in the exploration phase, may not produce petroleum, conduct drilling tests, and extend well tests or any other similar test without written consent. So all this is to just ensure that the environmental authorization issues and every other issue, compliance issues that are required, are complied with. Section 54 provides that when there's a discovery that is made, the holder must notify the agency within 5 days of such discovery. Clause 58 is administrative also, looking at the issue of that there is no progression from one phase to the other in terms of the production phase. And then clause 59 speaks to the application process, which may not progress to the production phase within 120 days from the date of receipt. So this one ensures that there's time frames within the administration of licenses or phases of production or exploration within PASA. 61 provide that the petroleum agency may, having regard to the national interest and in consultation with the minister, postpone the development of a petroleum field. This is important if there is an issue or PASA had done some research and pick up that they will have to postpone the development. And at a later stage, PASA must also ensure that that period that they had postponed is recovered with an equal number of years. If it's 1 year, they will have to also make sure that they extend for a year, depending on the period that they will have postponed. Clause 62 provides for a holder of petroleum right that they may not progress to the second or further terms. So this is mostly administrative. 63 provide for exceptions under which the petroleum agency must grant approval for the holder of a petroleum right and to progress to the next term. And 64 provides that minister may, after the expiry date of the initial term of the production phase, having regard to the need for the state to derive a fair share of benefits from the right production of its petroleum resources, amend an existing term and condition or insert a new term. So that will be administrative, but in consultation with the minister. Clause 68 provides for the petroleum agency that they may direct that upstream petroleum facilities which are owned by petroleum holder be used by third parties if warranted by considerations of efficient operation and resource management. So this applies to when one has infrastructure. The bill allows that there must be access provided for third parties to ensure that there is orderly development of petroleum resources. As we know that infrastructure in this space is very expensive. Clause 77 provides that the holder of petroleum right must notify the agency of any petroleum accumulation which extend beyond the boundaries of its areas. It further states that to ensure optimum recovery of petroleum and petroleum operation must be carried out on the basis of a unitized development where petroleum accumulation extend beyond the boundaries of the right and at least one holder has made a declaration. So if there are two companies and their resources extend beyond their right or their boundaries, they must work together. The companies must work together, unitized, so that is collaboration and that there is orderly development to ensure that at least there is understanding in terms of those discoveries. And then 78, on the other hand, it speaks to where there's an accumulation of petroleum that extend onto the land or a continental shelf of another country, which is similar to South Africa currently has share a continental shelf with Namibia. So there is a view that those countries must reach an agreement to ensure that there is efficient coordination of petroleum activities in those areas. Clause 79 provides for submission of information and data by the holder of reconnaissance permit and petroleum right to the Petroleum Agency. This information includes geological, geophysical, technical and financial reports, studies and analysis. So we as the department believe that we need to have a repository of information in terms of exploration or in terms of petroleum resources in the country. This is the same situation, or is the same process that we follow in mining, where data is submitted to the CGS, the Council for Geoscience. So it's not a new thing. So PASA will not struggle to handle this kind of information. Clause 84 provides for a issuing of closure of certificates. So this is to ensure that the right holder remains responsible for any environmental liability, pollution, ecological degradation, and the pumping of and treatment of extraneous water, and compliance with condition of the environmental authorization and the management and sustainable of closure thereof, until the minister has issued a closure certificate. We are now saying that to ensure that the state does not incur liability or after the right holder has finished production, they must ensure that they have a closure certificate. There will be conditions, terms and conditions that accompanies that closure certificate. And we then, under clause 87, provided for financial guarantee for that rehabilitation. So this clause outlines that the process within which the right holder must, within 60 days, ensure that they, before a notarial execution, that guarantee, financial guarantee, is made available, and there is sufficient funds for the fulfillment of exploration or production in respect for the applicable term, including for rehabilitation. Clause 88 provides for exception under which the minister may suspend or cancel permit or right. And clause 89 provides for restriction or prohibition of exploration and production on certain land or blocks. And 90 provides for optimal production of petroleum resources and direct a holder of a right to take corrective measures if the petroleum is not being produced optimally. So in the event PASA, because they will be monitoring the production of these companies, there is an issue around not optimally producing the resources, there is corrective measures that PASA can advise the right holder to correct and ensure that that state is corrected. Clause 92 provides for the minister's power, provide ministers with power to expropriate property for the purpose of exploration and production. We will note that the department is not the custodian to expropriate land, and we will do then, this will be done in accordance with the Constitution, Section 25, 2 and 3, and further that will be done with the Expropriation Act, to ensure that the compensation that is paid after expropriation is in line with those legislation. And we have in the bill also provided in Schedule 1 the comprehensive transitional provisions to affirm security of tenure of existing permits or rights by giving them an opportunity to transition to this act, meaning there will be a period, or there are situations case by case, obviously, wherein the transition will be made. In terms of pending applications, meaning those that's already in the system, the exploration right, permission to remove and dispose, the reconnaissance permit and production right, and those pending application will be given transition. And once finalized, in terms of existing rights, the same will be applied to ensure that the terms and conditions, specifically maybe relating to issues like SLP, their work program, and BEE, they are allowed to transition to comply with the requirements or provisions of the bill once it's signed into act. And the way forward is that once the process of the National Council of Provinces is finalized, the bill will be passed into law. And this is, we believe, it is a critical step for the development and growth of South African oil and gas sector. Thank you, Honorable Chairperson and honorable members. Our presentation ends here.
Thank you very much. We really do appreciate the presentation. And I must just commend you on how you formatted it. I think it really helps us who are charged with lawmaking at the end of the day to be able to assess this more critically with the help of your salient points listed. All right, so members, with that, I'll now provide you and any members of the public who've joined an opportunity to ask any questions. So please use the raise hand function to indicate if you have any questions. The first hand I see is from Honorable Mvimbi.
Good morning, Chairperson. Can you hear me?
Loud and clear.
Thank you very much, Chairperson, and good morning to everybody. My apologies, by the time you were asking for people to introduce themselves, I think I was already, I missed that opportunity. Therefore, I'd like to introduce myself. I'm Lulama Mvimbi. I'm the alternate member of the committee. Thank you very much also to the department for such a comprehensive and a very enlightening, well-crafted presentation. I think I only had two questions, Chairperson. I think it's also around the section 30 or 31 that has got to do with participation of Black person as well as the participation of the state. I see when it comes to Black person, it talks, I know, while I understand that it says the minimum is 10% ownership. Just want to check as to whether what formula informs that. How did the department arrive at 10%? Because there might be other reasons, although I don't really agree with the 10%. I think it should be more, but there might have been convincing reasons and calculations that have been made in order to arrive at 10%. I'm raising this because I think Black population is probably amounting to more than 80% of the population. But of course, there might have been good reason why it has put it at 10%. And also the involvement of the state in this, and I think there's also a figure of 20%. If the state is the custodian of our mineral resources, will it not have been better for the department to have proposed maybe at least 50% ownership by the state? That therefore, I mean, I know that in terms of corporate law as well, the percentage ownership also got to do with voting rights and all those kind of things. Because there's no way that they could have increased, especially the participation of the state to at least 50%. Thank you very much, Chairperson. I'll listen to the answers. Thanks.
Thank you very much. I recognize Member Nkondlo.
Morning, Chairperson, and good morning to colleagues and the officials from the department. Thank you for the presentation. I just have two issues. One, given the historical evolution of this act or reference that was made, I think, in the early slides, I'm just interested to know is that to date, does it mean outside of the process of the department starting to annex the petroleum and gas legislation, there hasn't been any any legal standing about any exploration or production of gas and petroleum in South Africa. I just want to understand that before this period, which I think is about, I think now in the 2000s, according to that presentation or that particular slide. And second to that, Chair, is that what then is actually given legal grounds to the current gas explorations that are taking place in the country. That includes the gas exploration, I think, that was found in Mossel Bay, I think, including the one in Beaufort West, if not somewhere in Central Karoo. So I'm interested in that, as the presentation was just explaining our current legislative environment in South Africa around petroleum and gas. That's my first question. My second one is that I think related to what Member Mvimbi is asking about the targeted or the black participation, as it were. My questions there is the notion of once empowered, always empowered within the BBBE development itself, from the BEE to the BBBE. Was this issue of once empowered and always empowered not raised as one of the challenges within the BBBE process, particularly because what it does, it gives a falsified impression about a BBBE status of an entity, which would include issues of fronting, if such is not necessarily, if such a blank check is provided. So I'm interested to if the department, even in this particular bill, provides a basis of such a principle within this petroleum and gas environment, if we are not going to be repeating what actually has been seen as limitations of implementing this notion or noble intent of black participation, if we use such principles. Lastly, is to say, what is the extent, indeed, again now, of these issues, given how the notion of government allowing or according percentages to black participation, to be contested by others, in the current environment. So I'm trying to understand whether, in following what has been happening in the public discourse, what are the potentials of getting these issues when I think the matters of consultation in the public, as it were, and the presenter has mentioned, could be actually contested. So I think those are my areas of clarity seeking, Chair. Thank you very much.
Thank you very much. I recognize Member van der Westhuizen.
Good morning again, Chair and colleagues, and thank you for the presentation. Chair, it is clear that we are dealing here with a significant piece of new legislation, proposed legislation. May I just at the onset ask the presenters, I don't know if they will have to present to other provinces as well, but on the first page, it starts with the nomenclature that it says an act. I think this is still a bill. And I think the heading on the first page actually needs to be adjusted and changed from an act to the bill. My questions are the following. The first one is in terms of the term discovery, and then there's also the term commercial discovery of petroleum products, and the obligation to report any discovery within 5 days. Now, I do believe that the word discovery, you can have these things in various quantities. When is when you sniff some gas or something like that through your probes, will even the minutest presence of fossil fuel or fossil products be seen as a discovery? Shouldn't there be at least a minimum threshold above which this should be then reported to the department? That would be my first question. The second one, Chair, I also wear the cap of the chair of the Standing Committee on, amongst other things, environmental affairs. And we do know that while fossil fuels have brought huge benefits, financial benefits, to a number of countries, and even to this country through the Mars gas plant when it was still operational, and we still were able to access the reserves that existed at the time. But we do know that this is a highly controversial issue, the whole use of fossil fuels, etc. And perhaps if we could just get an indication of what protection there will be for the environment, apart from the National Environmental Management Act's provisions that apply and that are referred to. For example, we also have in other legislation that money should be set aside for rehabilitation once a mine closes down. Now, whereas the exploration of petroleum doesn't always lead to the same level of environmental disruption, if I can use that word, I believe there should also be the possibility or not possibility, but there should also be the ability to have money available once petroleum and gas exploration has taken place, or even the production thereof, and it closes down, that the environment should be restored to as close as what it was before as possible. Yet I do not see any rehabilitation funding being provided for in this legislation. And then just on the topic that my colleagues raised earlier, I also do not see in this legislation any effort to broaden the base of ownership, or perhaps people benefiting from this legislation. It seems to me as if the same few capital rich people may take up these percentages in this legislation and just increase the gap between those that have already benefited from such schemes and those that will forever be excluded because they're not able to contribute the same level of capital and buy shares, etc., into ventures of this nature. Thank you, Chair.
Thank you very much, Member. I recognize, I believe that's a follow-up hand or an additional hand from Member Nkondlo.
Yes, Chair. Sorry, before they answer, I just wanted to also, I think, taking from what Member Andrikas have raised, if they could also in their response, I didn't hear about community beneficiation. And I'm raising this because one of the big issues which we have seen in the broad mineral or mineral exploration in the country is the protest from the communities, particularly as what Member Andrikas as the chair of environment, the environmental degradation, the change in the economic landscape of those communities, let alone involvement or generational poverty. That actually some of these explorations do not even manage. They become a high tower in a community that is poor and people do not benefit. And I think there's ample in other areas, even in the minerals, where there's been some dispensation that gets to be declared as part of the legislation and obligations of those who actually take up these. So I'm interested, perhaps I didn't hear, I've missed that, if such has been included in this legislation. Thank you, Chair.
Thank you very much. Before I hand over to the department, I do have a few questions I'd like to put through in this round as well. So my first question essentially is, what is going to be the interplay between the UPRD and the MRDP? So does this mean that the regulations that deal with gas and oil under the MRDP will fall away and be replaced by the new bill? If I could get some details on that. Then there were countries mentioned in terms of benchmarking. I think Congo was mentioned as one of them. If I could just get a better understanding of what metrics were looked at in this benchmarking comparison and what were the findings of those benchmarks in terms of what a bill like this should be doing. Also, whether the bill does actually define the difference between deep and shallow waters. I think this is an important thing to consider, particularly in terms of our international security, as there'll be implications there. And then, so noting that there are rights set for exploration and discovery and licensing, I wanted to understand if there were any punitive measures stipulated in the bill for those who act outside of their rights. If not, why not? Because if a person contravenes their right and there is no punitive measure, then they may simply just continue to do so. And then I was also interested in the shares. So I just wanted to get a better understanding on what is the class of the shares? Does it provide any voting rights, particularly for like, there was I think a petroleum entity that was discussed. And then also noting that the dilution was limited at 30%, if I could understand why that was. So to break that question up into whether there is a voting right or what the class of shares are and why the limit of the dilution. All right, with that, I'll hand back to the department. Over to you, Dima.
Thank you, Honorable Chair. We will take bits and bits and chunks of questions, and my colleagues are also here. Some they will also assist. So thank you for the questions that were raised and comments that were made. In terms of the first question that were asked by Honorable Lulama, I think he is mostly on the issue of Section 31. 31 refers to participation by Black persons and 34 referred by the state. So his view was that why limit the shareholding of the state of the Black persons to 10%? And one of the considerations that we have made in terms of participation in the ownership, we have done, the PASA has done some work to just look at the cost. Besides the cost, I mean the intensive nature in which this exploration will take place. There are 5 phases of upstream project development, which has the exploration, appraisal, feasibility studies, project development, and petroleum production up until production. And one of the analysis we have done is that just to have a petroleum right, for an example, on onshore, it will cost to around $451 US, and we believed that 10% of that as a minimum would be at least reasonable. But those that are having enough capital, they can participate to more than 10%. So it's not limited to 10%. And the other issue relating to why the state cannot increase their shareholding to 50%, what have we considered? Is that also the same is 20%, but it is a minimum. We know that right holders would have spent a lot of money in this development of the resources. So we believe that when the state has a company called the SNPC, they also have a right to can participate on their own. It doesn't limit them. But in the beginning, of this process, when they will be part of the shareholding, they will probably learn a lot, and they'll probably be in a position to can acquire petroleum rights on their own. But 20% was found to be more reasonable, looking at the amount of capital that is required. And other issues relating to what will be required, environmental authorizations. There's a lot that we believe that if the state is given that fair initial participation, from there they can increase as they wish. And then we had a set of questions from Honorable Nobulum Konkondlo. So she asked that given the historical evolution of the legislation, as was shown in the slide, what was the legal standing of petroleum resources? I think one of the issues we mentioned that oil and gas has been regulated from 2002 using Chapter 6 of the Mineral, Petroleum and Resources Development Act. And we believed that because of its intensive nature and the complexity of the oil and gas sector, and that it's got economic value, it was important for us to have a dedicated legislation. So the legal standing had been provided for in Chapter 6 of the MPRDA. And the issue of Mossel Bay, I think I will allow my colleague to answer that one. What can give the legal standing in terms of the Mossel Bay shale gas? There is what is the legislative framework there relating to those discoveries? My colleague will answer. Let me skip it for now and let me go to the other one. The other one was the issue of once empowered, always empowered. There has been some issues in the BBBEE of fronting, and in the matter in terms of this bill, how is it addressed to ensure that we do not have the same issues that were raised there. So I think in terms of this bill, we did learn also from our mining, the mining industry, where in the 26% shareholding that had been prescribed by the MPRDA or in the mine to be complied for in the mining charter and the MPRDA, there was an issue of Black people entering and just leaving, and then the right holder will still need to replace them, and their shareholding will not be said is compliant. So in this one, we are saying if the Black persons exit the right holder still comply with that transformation imperative or with those credentials, empowerment credentials. So we have sort of circumvented that in this bill, Chair. In terms of percentage Black participation, the issues of consultation and where the communities can raise issues and they are not attended to, we are saying that in terms of Section 19, Section 19 provide for consultation by PASA, meaning that when the right holder has been granted I submitted the application to PASA. PASA has 30 days to ensure that within that they notify the communities and they go and do a consultation with those communities or interested and affected parties, because it might be interested which are investors from overseas, or it might be communities. That's why we speak to interested and affected parties. That consultation is meant to address those issues that the communities or parties around the area might have raised. And if there is issues that there is disagreements, there is a committee that the minister, the Petroleum Resource Development Committee, that will address those issues raised by the concerned parties. And then Section 19 further provides for the consultation, again, by the right holder. The applicant must, within a certain period,
Apologies, I'm not sure if it's just me, but I'm no longer able to hear.
Indeed.
Okay.
Yes, You've lost it.
Ms. Mamokale, just to flag with you that we're no longer able to hear you. So I think we'll just give you a minute. If you could please indicate when your sound is back. In the meantime, Ms. Adams, could I ask if the IT team could please reach out to DMYE officials to assist?
Chair, yes, I'm busy contacting them now.
Thank you very much. I imagine this might be a load shedding issue. Seems that they've dropped off the call. Okay, readmitting. Welcome back, Ms. Mamokale. I just
All
wanted
right,
to
thank you.
I think our
I'm
network.
not sure at what point did members lose me, Chair. If you can indicate, or do you want me to start with the issues that were raised by Honorable Nombulumko?
Yes, please do.
Oh, okay. So her first question was regarding the historical context that we have brought, and in terms of the regulation of oil and gas. And she was asking what has been the legal standing in terms of exploration of oil and gas. And we are saying that Chapter 6 of the Mineral Resources Development and Petroleum Development Act currently does regulate oil and gas. There's a legal framework in that chapter. So it is not left in limbo, but the issue is that we needed to have a dedicated legislation for petroleum and resources. That's why we are asking for this bill to be processed. And then the second question was around the issue of once empowered, always empowered, that there has been issues raised within the EE Act, and there has been some fronting experience within that area. And our view is that we know that even in our mining context, the once empowered, always empowered has always been an issue. We also have had court challenges relating to that. So we are learning from that experience and making sure that in this bill, we provide that once a right holder has empowerment from Black people, if they exit, that empowerment credentials remain compliant up until the term of the right has ended. And then there was an issue around the Black participation and the consultation relating to the communities or contestations that may be raised within that petroleum right. So we are saying clause 19 or section 19 of this bill provides for the consultation that PASA can do if once the application is received, they have an obligation to invite interested and affected parties, which in this case will include communities, considering that we are talking about also investors who may be interested parties. Then that engagement is done formally, and if there are issues that are raised and there's no agreement, the minister can also then appoint the committee, which we have mentioned in clause 21, that they will then deal with those contested issues until they are resolved. Then the production or the development of the resources does not proceed up until there is agreement. And then clause 20 Now, then is an alternative consultation provided for that the applicant themselves must go into those communities or in those areas where there's interested and affected parties and do a consultation. And the same process is followed in the event that there are contestations or there are issues that are still being raised. The committee will then be also appointed to ensure that those issues are resolved. So consultation, we have learned also, it's a contested area, and we are trying in this bill to ensure that that is fully catered for. And I think she also raised an issue around the issue of beneficiation, community beneficiation. So if you look at this bill, one of the provisions or one of the objects of the bill is to ensure that it provides for local content, and there must be a development of a strategy to enable skills development, and there should be local recruitment and national participation through supply of goods and services. So we are of the view that one of the critical areas we believe will form part of community beneficiation is that the petroleum right holder must ensure that they procure goods and services in those areas. They also make sure that they create skills programs to ensure that the community around there are empowered, because this is also an area of development which is a bit technical, and those that have the skills must not come into communities and leave them without any knowledge in terms of petroleum resources. Let me allow my colleague to address the issue around the discovery before I move to the next set of questions, Chair.
Okay, thank you, Dr. Masakwa. I think there was a question from Andrikas on a commercial discovery as to whether fossil fuel will be seen as a discovery. I think there is we know that oil and gas, there's a debate going on. They are classified as fossil fuel, but however, there are benefits in terms of exploration and production of gas. As we know that gas emits less greenhouse gases. So for us, a discovery, whether for us discovery, we refer to oil and gas as this legislation is dedicated to exploration and production of oil and gas. And I think there was also a question on when does the bill, okay, I think there was a question on penalties. Are there any punitive measures for those acting outside the right? Yes, there are punitive measures. We do have section 102 in the Act which provide for penalties, and also we do have section 103 which also provide for administrative penalties for any person who fails to comply with the provision of the Act. And I think there was also a question on the, I think, the legal standing in terms of the Beaufort West gas that was discovered. And I think from my side, I understand as meaning the shale gas discovery that was discovered in the Karoo, if I'm not misquoting what the Mrs. Nombulango was asking. So in terms of the shale gas discovery, as you are aware, there was a moratorium that was put in place by the department. And one of the reasons for that moratorium is to allow for the development of regulations that will regulate the shale gas. So currently, as I may speak, the Department of Environmental Affairs and Water Affairs, they are currently developing those regulations relating to shale gas. Yeah, I think that is all. Yeah.
All right. Chairperson, there was also a question by Honorable Andrikas. I think the third question that he was asking was that what other protection there will be apart from NEMA in terms of these petroleum development resources. And we are saying Section 87 in this Act provide for financial guarantee in to ensure that there is rehabilitation. So we are of the view that the state cannot carry the liability as we have some issues relating to mining. The liability must still remain with the right holder to ensure that the minister issues a closure certificate and there is compliance in line with their work program and also their environmental authorization fully before that a certificate is closed, the certificate is issued. And the financial guarantee must demonstrate the capacity and the sufficient funds that will ensure that the processes related to closure and once the right exploitation or the petroleum exploitation process is finalized, that is done. So that is another leg of protection that the bill does offer. And then there was a Honorable Chair asked some few questions. Okay, there's also the third question by Honorable Andrikas relating to there is no effort to broaden the empowerment ownership level. And we are saying that I think we've answered that question in another manner to say 10% is just that minimum. And also remember the Black persons can also participate on their own, wherein the participation of they cannot dilute by not less than 30% if they have their own right, they are getting into shareholding on their own. So there is an effort. That 10% minimum, we believe that will allow any, the wealth gap of South Africa, anyone with less capital or anyone with enough capital just to enter. Because if we had put it at 50, it means those with little or those with a limited resources will not be able to enter the sector. But the 10%, at least for us, is a starting point. And those with more can be allowed to enter into empowerment transaction of more than 10%, up to 50, to wherever they level that they can on any percentage. So those are efforts that we believe the bill offers. And then Honorable Chairperson, you asked a question relating to the regulations in the MPRDA or that what will happen to them. So we have provided for the transitional arrangements. And where there are other provisions now which are new in this bill, we will develop regulations. There are certain things that we have emphasized or we have brought into this bill that will require us to develop regulations. And we will migrate those that are still relevant to the new act once it's enacted. And then there was a question on the matrix relating to the research on what was looked at. I think on the top of our head, we cannot remember exactly, but we looked at similar jurisdiction in terms of licensing, administration, in terms of the funding, in terms of, obviously, South Africa's context will be different in terms of empowerment, transaction, and transformation. That is a unique environment which will not be able to really sort of benchmark. But the technical issues and other related matters that South Africa could not have done without benchmarking, that was looked at, except those ones that are just unique to South Africa. In terms of the punitive measures, I think Ms. Stella answered that. Also, the question around why limited dilution. Yes, because if the ownership is up to 10%, we believe that at least let there be limit for those that want to exit, so that even the right holder, if they have the desire to still add on the 5% to remain with 10%, it's not like they're starting from scratch. And in terms of the basis of the dilution, and it's also related to the issues relating to how the amount of work that needs to be done and the amount of capital that needs to be raised. So even when the main reason why dilution will be allowed is when the black persons want to raise capital. That is the only reason, mainly, that we will allow dilution. So there's a various dimension of issues that we look at, but dilution, we believe, should be limited. There was a view around maybe we should do intra-dilution, but that is not something that we can control, because these are empowerment transactions within commercial terms. So I do believe, Honorable, that we have tried to cover, unless I missed something, Chair.
I believe you have covered it, but if there are follow-up questions and members feel that these are not addressed, we'll give them an opportunity now to make those follow-ups and additional questions. So with that, members, if you could please raise your hands to indicate whether you have any follow-ups. Seems that you were very, very comprehensive. Mbembe.
Thank you very much, Chairperson, and thank you very much, Ms. Mamukhale, for the answers, and to everybody who has given answers. Just a follow-up on the original question I raised around the ownership of 10% for Black persons. I appreciate the answer that has been given, and I was raising the question on the context that if you look at most of the petroleum business right throughout the country, especially say maybe even petroleum companies that has got exploration resources and also exploration powers and rights. Even in South Africa, those that even supply petrol, most of them are white owned. There's actually very minimum, almost to no existence of Black ownership in the petroleum industry. It's not only white owned, but it's also foreign owned. And if you look at most of the petroleum operators in South Africa, not only predominantly white, but they are also foreign owned. So there is completely limited ownership of not only Black people, but it's also limited ownership of local owned by local, I mean South Africans. So it was really in that context that I was raising the issue of 10%. And knowing that most of these things are actually enforced through laws. So will it be possible to say, to make, of course, the 10% as a minimum, and even maybe stipulate in the act, because when some of these petroleum operators, petroleum ownership, when they've got 10% that has been indicated, they will always like people to actually stick to that 10% and not more. Can it be explicit in the act, in the bill, when the bill becomes the act, that it's minimum 10% up to more than 50%? If maybe there can be some kind of a phrase, because I'm just fearing that when the petroleum owners and operators negotiate, they are actually very hard negotiators. They will always like to pin Black people to that 10% and nothing more. If it can be explicitly stipulated in the act eventually that it minimum 10% to up to more than 50% for that matter. I don't know whether will that be possible for it to be stipulated in the act. Thank you very much, Chairperson.
Thank you very much. I have a few follow-ups from my side as well. My first was, I apologize if you did explain this, but I wasn't quite clear in terms of the class of shares and whether there were any voting rights that would be given, particularly to Black persons who would receive those shares. And then further questions. My first question is, what linkages are there in terms of South Africa's international commitment to reducing greenhouse gas emissions I think here, for example, of the SDGs and global COP27 commitments, and which will probably be revised quite soon with COP28. And then I also wanted to understand how might climate change impacts require changes in infrastructure planning for the petroleum sector, whether this is being considered in the bill, and maybe why there is no mention, seemingly, of climate change in the bill. Also, in terms of the bill, I'm not quite clear in terms of the role of the legislation in terms of informing and contributing to integrated planning around energy, particularly in terms of the integrated energy plan and the integrated resources plan. And then lastly, for me, what clarity is needed in the management and disposal of petroleum extracted during the exploration phase of applications, particularly given the concern of potential duration of exploration rights. With that, I'll hand back to Diamari.
Kali, can you repeat the last question on the issue? Honorable Chairperson, can you kindly repeat
The last
question?
No problem. That question is, what clarity is needed regarding the management and disposal of petroleum extracted during the exploration phase of applications, particularly given the potential duration of exploration rights?
Okay.
Over to you.
I think in climate change.
Sorry, did you need me to repeat my question on climate change?
No, it's fine. Thanks. I think let's start with the follow-up by Honorable Nobulumko, if I'm not mistaken. Oh no, Honorable Mulama. So his view is that why can't, because there is dominance of white companies and also foreign companies in South Africa when it comes to petroleum resources. We believe that, yes, definitely, that's why there's a need for us to ensure that there is Black participations. If you look at the current Chapter 6, the way it is crafted, there was not going to be any participation or any allowance for Black or new entrants in the sector. We do agree. Obviously, it's also related to the older dispensation that it is dominated by other people rather than Black. But the minimum of 10% is clearly allocated, and it says undivided participation. In terms of limiting up to 50%, I think if we say up to 50%, it's gonna now for us we will be interfering with commercial terms of businesses. So we believe if we say a minimum of 10%, people can go up to 90%, depending on their pockets. So in that way, Honorable, we do believe that that will also open the market for Black entrants. Don't forget that there's also another section that speaks to Black persons entering on their own, wherein the dilution is also, and also Minister will designate blocks. So there is a lot of avenues in this bill that allows for Black participation, because those blocks that Minister would have advertised are only for Blacks. And also there are blocks that he will advertise in terms to ensure security of supply, which will also be opened for Black people on a first come first served basis. So we are of the view that in terms of Black empowerment, this bill has tried to open up the market. Honorable Kali, the first question was related to COP27 and issues of climate change. We believe that as we work as a department and also as we introduce legislation, the bill will comply with all the other exploration of gas and oil. We will have to comply with other carbon emission legislation, issues related to environment. Yes, we work with DFFE in terms of environmental authorization. We are not the competent authority, and DFFE works closer with us. That's why all our applications will go there, and we believe they will be able to cover all avenues related to climate change and environmental issues. And the question on whether they vote, in terms of ownership, the Black Panther, they will have voting rights. Definitely, they will have voting rights in the structure of their ownership. And the question on IEP, what is its space in the IEPs? Integrated energy planning, petroleum resources. So this is more on the products, because remember, we are talking about oil and gas production, and the products become petrol, oil, diesel in the what is it, in the downstream, wherein they become part of the energy planning value chain, and our integrated energy plan and of the department speaks to energy security from that end. So it's a whole, if we don't have exploration of oil and gas, the products will suffer on the other end, and the security of supply in terms of the energy sources will be a challenge in the country. That's how we understand it. And then the last question on what is the management, I think we lost the last part. Honorable Kali, sorry, we lost the last part of that question, but we ended up at what is the management in terms of disposal of during the petroleum right. There is a missing word that there we didn't get. All of us, maybe we are missing the English there. Honorable Kali.
That was my last question.
Yeah, the last question.
Okay,
We've been missing it.
No problem. Let me give it another try.
Yes.
So the question was, what clarity is needed regarding the management and disposal of petroleum extracted during the exploration phase of applications, particularly given the potential duration of exploration rights? So basically, how are they going to manage extracted petroleum throughout the different phases?
How legislation will apply within the whole value chain. I think, Honorable Kali, with that, as Dr. Masakwa has indicated, that all applicable legislation, environment, waste, they will apply to this legislation. So in respect of the disposal and management of oil and gas during exploration and production, that is also going to be administered by or it will be taken care under those standards that are required either by the Waste Act, by environmental legislations, health and safety. So all applicable legislation, they will cater for those exploration and production of resources.
Perfect, thank you. All right, so with that, I think you've concluded your questions. I just want to check with members if there are any final questions. I see Member van der Westhuizen.
Thank you, Chair. Chair, my concern is still with the rehabilitation. Once exploration has stopped, what we see, and you're quite right, some money must be set aside, or mines companies, petroleum companies must provide for a pool of funds to rehabilitate after exploration. But now what we often find is that the initial company is quite profitable. It's a subsidiary of a big international group often, because this kind of work requires vast sums of capital investment, which quite often South African companies don't have. But then as the profitability of the company goes down, as you know, they've now skim the cream off, and then they sell that subsidiary to another company, and then they sell it to a third and smaller company that hasn't got the high overhead costs of the first two. And so we continue until eventually, quite often, the subsidiary goes bankrupt. My concern is, and perhaps you can just explain to me how it works, how do we ensure that as the company's financial position deteriorates, that pool of money that's been set aside for exploration, for rehabilitation, apologies, for rehabilitation, that pool is ring-fenced and therefore still safe. And can I say, my impression is that it remains the same company that's been passed on to a smaller and smaller and smaller holding company or parent company. So there's no change in the transfer of the rights. The rights remain with that original company. It's just that this company, in its totality, is being passed on from one parent company to another, to another, to another, as they I almost want to say fade in terms of their profitability and their activities. And it's quite often at the end where we then are left with a derelict mine or situation. So perhaps if you could just help me allay my fears as to that pool of money for the final rehabilitation will be still available. The second one is, what we now know is that unlike in the past when people believed that the water and the mineral below their land, and I'm talking particularly, let's say, of farmers with vast tracts of land, that water and minerals now belong to the state and not to the owner of the land. And we sometimes hear that the owner of the land says, but I've got no control about what's happening within the boundaries of my land when it comes to the mining of the resources below the surface. What protection would there be for such a landowner so that, you know, eventually that owner's own activities are not infringed on? And perhaps even, and we know about the fears that the groundwater resources in the Karoo might be irrevocably be damaged by shale gas exploitation. To what extent would we be able to assure the owners of those land that they will not be in a worse off situation once the petroleum or other minerals have been extracted from that land? And then, Chair, if I can just ask, in terms of the repeal of certain sections of the 2002 legislation, the mineral and petroleum, I think that one was called the Mineral and Petroleum Resources Act. If we could just ask that, you know, eventually we are also served with a copy of that act with its amendments since 2002, so that we are able to see which sections will now be repealed, because it seems to me that there are quite a number of clauses in that act that are now being either repealed or they are being amended by this bill. Thank you.
Thank you very much, Member. I'll hand straight back to DMRE. Just members noting, this is our final round of questions before we move on. Over to you, DMRE.
Yes. Thank you, Honorable Enriquez, for the questions. I think the first one relates to our rehabilitation, to ensure that how do we ensure that the pool of funds in terms of movement, when there is transactions that are moving from one company to the other, and your concern was more on those that will move from a bigger company to a smaller company, and sometimes the issues of liability. Maybe let me start by saying Section 28 speaks to the transferability of the incumbent right. So that is provided for on how the right can be transferred, or how the ownership can be transferred, the company move from the one to the other. And it's a process that it's prescribed, and PASA and the minister. So it's a whole long process. So nothing will be left to chance in terms of that. And the issue of the ring-fenced money is linked to the right, not the company. And because the right has ring-fenced that rehabilitation fund, they will have to ensure that the department or PASA will be monitoring that the use of the ring-fence funds is to ensure that there is no liability, or the land or the offshore in sea, where the production was happening, issues are left unattended. And linked to that then becomes the closure certificate. So it's a whole lot of process, and that is monitored, and the step by step up until there is transferability, the liability. The state has learned a lot from mining, because we have around 6,000 sites that the state had to rehabilitate. So on this side, we are making sure that we don't have that issue again. And then in terms of the land issue, I will allow my colleague to come in and assist. And then also with a copy of the MPRDA, we will send that through our secretariat. No, you can.
Thank you very much.
Now, the last question around the land issue, there will be consultation with the landowner. The question was around what protection will we have so that the owners' activities are not infringed, or they are not left worse off than before there was exploitation of the petroleum resources. So that consultation is very important, and it will outline all the issues that the landowner would have concern of must be addressed before there is any activity that the petroleum right holder will do.
Thank you very much. Van der Westhuizen, I note that you have a follow-up question. I will allow it, but please note that the last round was the previous round.
Thank you, Chair. It's indeed follow-ups. I hear the assurance that landowners' rights will be protected, but perhaps if we could just get the clause in which provision for that is being made. And the same with the ring-fenced money. As I've said, it's not as if the right will be transferred to a new owner. It's the company that will be transferred to a new parent company. So in terms of the registration of shares and so on, there won't be any changes. We won't perhaps even pick that up at the department when that, can I call it mine, or in this case, then company is being transferred, to another holding company, How can we ensure that ring-fenced amount is still then protected to the very end? Because I don't see that. Perhaps you can just point me to the clause to allay my fears in this regard. Thank you, Chair.
Thank you very much. I will hand over to DMRE for that final question. If there are any follow-ups, members, please note this is not our first engagement with DMRE. We will meet them again, but you can also make a resolution for follow-up information if necessary. Over to DMRE. DMRE? Okay, there we go.
So the issue of the financial guarantee, that the money, how can we ensure that the money is ring-fenced? So this will be done in line with NEMA. And in terms of administration, that is under Section 84. That's the clause that I think he asked for a specific clause under the issuing of a closure certificate. So That section has around section 7 or 8 that outlines the process. And then the last concern, I think, was around, I lost it. What was the last?
Member van der Westhuizen, if you could just reiterate that last concern, please.
That last concern, the repeal of no, the land issue, I think. Let him repeat. Yes.
Yeah, no, Chair. Again, we were assured that, you know, there will be consultation with the landowner, etc.
Yeah.
Perhaps if we could just get the clause that will ensure that such
It's
consultation
19 and 20.
is protected.
It's 19 and 20.
Thank you very much. All right, with that, I would now just like to thank the officials who have joined us today from DMRE. I know this is not our last engagement, but it's certainly our first. And so thank you very much for the time you've taken today to meet with us, to brief us, and to start getting our brains thinking about all things upstream. With that, I would like to excuse you, and again, thank you. And from there, we'll move on to our way forward. Of course, the other stakeholders who have been invited today are pleased to remain online. We're only excusing DMRE at this point. All right, members, we're going to kick off in terms of the way forward on the bill. I know we have 20 minutes left, so I'll try and make this as short and sweet as possible. I think the first thing I just want to flag is that the NCOP has provided legislators with a program for bills. The public hearings, if the committee chooses to hold hearings, should be held in February of 2024. The negotiating mandate should be complete by the 5th of March, and the final mandate is due on the 19th of March. So members, with that, I put it to you as to whether or not we will move forward and have public hearings. And if so, if I could get an indication of how many public hearings to be held and where, I would make a suggestion as well, if you would indulge me, that we do move ahead with 4. And to my mind, I think it would make the most sense to go to Mossel Bay, to Beaufort West, and Cape Town, and I think maybe one in Saldanha, given the prevalence of upstream in those communities. But members, I put it to you as a committee to understand what you feel would be most appropriate as a way forward. Member van der Westhuizen.
Yes, thank you, Chair. I support those proposals. Perhaps the one on the West Coast could even be slightly a little bit more north, or one could perhaps have an extra one on the West Coast. As you know, this exploration often goes with seismic, activities, which in the past have caused a lot of concern from particularly your fishing communities and those that are dependent on the sea for their livelihoods. And I would therefore strongly urge that we also engage with the public there. But first, Chair, I think we will be calling for people to just first register their interest in this by means of also calling for written comments by members of the public, and perhaps our response might be guided by the amount of written comments received, and also the role players that have indicated that they do have an interest in this legislation. Thank you.
Thank you very much, Member. I recognize Member Nkondlo.
Chair, I support Member Andrika's proposals in support of yours, and think that also, whilst there is no exploration in the metro, the financing, if we think about the more finance sector, is in the main in the city. because all of those explorations indirectly would have to be financed, particularly by your banks, commercial sector in particular. So over and above what government or other funds are available. So it's important to also, I think, give regard to those in as far as Metro is concerned. But I also wanted to say, Chair, perhaps one of the things we may need to consider, especially to these kind of technical bills of this nature, is actually to start thinking about a more targeted, in addition, a more targeted approach to this. And I'm referring, I think, if we consider when we're doing the, what do you call this? The words like to just slip out of my mind. But I think
Friday.
that's, yeah, it is Friday. Thank you, Chair. I think for me, it's important to also consider, the experts. If we think of these kind of bills, where we are more directed in terms of our invites, like I think in this bill that I'm trying to think, we did, I think, 2 bills at the same time. Copyright, yes, thank you, Chair. Copyright, where we were able to even attract, some of the academics from Stellenbosch and others. So I'm just saying, I think it's important because it also enrich ourselves as lawmakers, also just to get some of those that are dealing with these matters on a day-to-day, because we know that these kind of technical bills, sometimes we end up being subjected to only views of the technocrats that are driving these bills and limiting our understanding, especially on some of the nuances of these bills. So I think that's just one issue I just would wanted to add, particularly to our outreach office that helps us in terms of advertising these kinds of public hearings. Thank you very much.
Absolutely agreed, 100%. Okay, so I think we've gotten guidance from Member van der Westhuizen and Member Nkondlo on the way forward with public hearings, as well as Member Philanda in the chat. So essentially we're happy with the 4 in principle, but we'll take guidance as well from our information received. Member Mvimbi? Okay, with that, I'll move on to the next point.
No, Chairperson,
So, yes?
you were calling me?
You were unmuted and I wanted to check if you wanted to speak.
No, I'm fine, Chairperson. My silence means consent.
Okay. With that, members, according to the NTOP's program, advertising should be placed in between December 2023 and January 2024. Members, I personally am not very comfortable with running the advertisements throughout December. My feeling is that we should look from January onwards when people are back at their laptops and back reading their newspapers. And so in terms of advertising, we have a choice between mainstream and community papers, as well as social media. The Western Cape Provincial Parliament has a paid social media policy, which we can also use. But committee, what I'd like to put to use to decide on the newspapers, mainstream and community, that we would like to advertise the bills in. So I'll just mention some of the mainstream and community papers that we used for the Copyright and Performance Protection Bill, but I think they do strike up a nice balance between regions and linguistic coverage. I only have one though for isiXhosa speakers, and so if anyone knows of another publication that we could possibly use, I would appreciate that. But the publications I'm looking at currently are Die Burger, mainstream, Argus, mainstream, Die Son, mainstream, Eikestad Nuus. We could or could not include that. That's like Stellenbosch, Overberg area. I mean, Cape Winelands area. Oudtshoorn Courant, Overberg, Westlander, that's the West Coast. Knysna, Plett Herald, George Herald, Mossel Bay Advertiser, those are all Garden Route. Die Courier, that's your central Karoo area. Bukani, that's the isiXhosa, and then the Hermanus Village News. So members, I just wanted to check in with you and see if you were happy with that mix in terms of print media. I recognise Member van der Westhuizen.
Yes, thank you, Chair. Chair, as much as we want to support the regional newspapers, I think our budgets are under severe pressure, and therefore I think we can leave it to you and the procedural officer after you've studied the budget and liaised with the administration. But I would suggest that we determine the following as minimum criteria: that an advertisement be placed in all three the languages in newspapers that serve those particular language groups, and that we at least cover all those newspapers, as you've mentioned, that have, can I call it, provincial wide coverage in terms of their distribution, etc. So perhaps not in all the smaller regional newspapers, but at least those that cover the whole of the Western Cape, and then, as I've said, in Afrikaans, English, and isiXhosa. That would be my suggestion. If there is additional funds available, please let's spread the word as wide as possible and support our regional newspapers. But I think we should today decide on at least a minimum level of printed media. Thank you.
Yes, thank you. That's a very good point, because as you'll remember, when we were looking at the 19th Amendment Bill, one innovation that we started within the Western Cape Provincial Parliament's advertising process was the use of paid for online advertising. And the reach is significant. It is a more modern way of advertising, more up-to-date way of advertising, but the cost is very high. And so members, through just to put to you, that was not something that I thought maybe we should consider, just given the dire financial case that we are currently in. But yes, I do note your point. Thank you very much, Member van der Westhuizen. All right, so with that, I'll move on to the advert. So the advert will request interested stakeholders submit comments via email and WhatsApp. Those include voice notes and messages, and that if stakeholders would like to make oral submissions, they should indicate so, and they will be invited to speak at public hearings. Also to note, the procedural officer will request that the Western Cape Provincial Parliament's communication sector secure radio slots for broadcasting call for comments. Essentially here, I'll provide voice notes that can be played on radio, and Matthijs, who I understand is not able to join us today, Matthijs will essentially provide a media plan once the advertising is finalized, and this will include posting on the Western Cape Provincial Parliament social media pages, as well as paid for social media advertising, which we utilized under the copyright and performance protection. I just want to get an indication of PEO with us.
Thank you, Chair. Yes, I'm here. Themba Keso.
Hi, Themba. Okay, so we're going to give you some work now. Apologies. Themba, our ask of you today, through you members, is essentially to request assistance with the public hearings. This would include sending information, the advert to affected stakeholders, using your network of community development workers, assisting with mobilizing members of the public to attend the hearings, and assisting with the coordination and procurement of transport requests from members of the public who would like to attend those hearings. Before I pull you in, Themba, I just want to check in with members to see if they are happy with that list of tasks that I feel we should consider delegating to PEO. I recognize Member van der Westhuizen.
Happy, Chair. Chair, may we just perhaps later on just quickly discuss the timelines as well?
No problem. All right. Themba, are you happy with that?
Thank you, Chair. I am happy with most of that. I just want to say that I will discuss obviously further with the procedural officer how we move forward in terms of administratively moving forward. And I want to say that I also agree with Member Nkondlo when she spoke earlier about the targeted approach, because obviously this seems like it's a specialized kind of a bill. It's not your normal bill. So we'll also definitely factor that in our quest to mobilize the participants. Thank you, Chair.
Thank you. You bring me on quite nicely to my next request. Do we still have Environmental Affairs and Development Planning on the call?
Yes, Chair, we in the call.
Fabulous. Committee, one thing that I would like to request is that we ask the department to also send the advert and bill to their interested stakeholders as a way for us to just broaden the reach, particularly to those who have specialized knowledge in the area. If you're happy with that, and if department is happy with that, then I think we can move on to the next point. Everybody's quiet. All right, so the next point would be to request the same of economic development and tourism. And then just to note that once advertising period concludes, the procedural officer will have limited time to collate the voice notes, the messages, the emailed comments, the requests for oral submissions, and to send the department or send to the Department of Mineral Resources the information or the responses in order to collate the matrix of submissions. Members, before we move on to any resolutions, I just want to check and see if there are any questions or clarity or any thoughts regarding the process that I've outlined and that we've discussed. Okay, I see none. Then I'll move on to resolutions. Members, if I can get an indication if there are any resolutions stemming from today. I recognize Member van der Westhuizen.
Yes, thank you, Chair. As I indicated, I am concerned about the timeline and that we will be under severe pressure to get our input to the NCOP. And I have been told that, we cannot advertise, or that the courts would really more than frown upon it if we advertise between the 15th of December and the 15th of January. On the other hand, we would like to give people, in my book, at least 21 days to be able to prepare submissions that they would like to make. And I was just wondering whether we shouldn't see if we could start with our advertising in the next 2 weeks. So even if we take into account that people might prefer to go on leave from the 15th of December to the 15th of January, at least they have had ample notice of any call for public comments. So that would be a suggestion for a resolution. The second one is, Chair, as I've indicated, I think we should also not be looking at this piece of legislation, but also at the legislation that will be recalled or amended by this piece of legislation. And here I'm particularly referring to Act 28 of 2002, the Mineral and Petroleum Resources Development Act, and its amendments since then. And then, Chair, as has been proposed in the chat, if we could ask the department, the national department, if they have done any socio-economic risk assessments on the bill in front of us. Perhaps not the full report, but if we could get at least a précis or a summary of the findings of any such assessments, should they have been, undertaken. I do know that there is an expectation that legislation should have a risk impact assessment done, and I think that would provide us with important information when considering this piece of legislation. Thank you very much.
Okay, thank you very much. I think I'd like to pull in Ms. Adams with regards to the timelines. One proposal, members, or one consideration is I'm personally quite weary of advertising in December. And my proposal would be that we do the advertising from January to early February, with the understanding that we can sufficiently undertake our public participation and do advertising at the same time. I say that under correction, and I would like to pull in Ms. Adams just to rectify anything I might have butchered.
Thank you, Chairperson. Good morning, members. The Chairperson is correct. That was my line of thinking as well. We could advertise in the first or second week of January, and then also extend the deadline for written comments into mid-February, when we would possibly finish our public hearings.
Members, are we happy with that approach? I recognize Member van der Westhuizen.
Chair, I'm particularly concerned about advertising when people are still on leave. And as I've said, I've been led to believe that advertising in the first 2 weeks of January may be frowned upon by the courts, as people may miss those advertisements. That is exactly my concern. And secondly, I do believe that, asking first, alerting people through the adverts to the opportunity to submit written comments, verbal comments, etc., via the WhatsApp channel as well, will then lead also to the invitation to attend public hearings. So in a sense, I think, people also need ample, can I call it, notice of intended public hearings. And I am concerned about the timeline next year. If Ms. Adams says no, we will still have enough time to prepare our responses to the National Council of Provinces. Then I'll be happy to hear that. But I am indeed concerned about advertising the first 2 weeks of January. Thank you.
I do hear your concern about advertising and the question of whether residents will be sufficiently informed ahead of time of the public hearings. I have the same concern with you with regards to people being away, except that my feeling is that people might also be away should we advertise in December. So this is a little bit of a damned if you do, damned if you don't situation. Perhaps if there are any other members who have thoughts on this, but I would just like to add that with the copyright and performance protection, we advertised those at the same time this year as the public participation, and we advertised them in the beginning of January, and we still received sufficient responses. So I do think that we will get sufficient responses, and we will be able to submit the information to the matrices timeously. But again, I'm just going to open the floor to any thoughts. Everyone's very quiet. All right, I'll just do a final check. Are there any further resolutions stemming from today? I see none. All right. With that, members, I would like to thank you for today. Thank you for helping me to interrogate this. And I think this is quite an interesting bill, quite an exciting bill. So I think we'll all enjoy getting our teeth into this one. But I wish you all a good Friday. And I hope that you managed to get a little bit of rest this weekend as things start to finally simmer down towards the December period. I hope you all have an excellent day. Goodbye. Meeting adjourned.
Goodbye, and thank you, Chairperson.